October 6 and 7, 2022 is when a joint operation descended upon Caribbean International Brewery Company Limited, located in Carmelita Village, Orange Walk. The 2 days raid resulted in the confiscation of $3.1 million, which was handed over to the Financial Intelligence Unit. Calling the raid unlawful and malicious, the company took legal action and through its lawyer, Dean Barrow, requested that the funds be returned in order to avoid bankruptcy. Believing that the monies may be linked to human trafficking and wanting to retain the cash until investigations are complete, the FIU lawyered up and retained the services of Godfrey Smith. For the past weeks, Magistrate Deborah Rogers has been hearing the case at the Orange Walk Magistrates Court. Last week, Monday, FIU's attorney, Godfrey Smith, requested the submission of an evidence that would strengthen the application for the continuous seizure of the $3.1 million for a period of 3 months. Today, when both parties went back to court, Smith was successful in submitting that evidence.
It's effectively over in the sense that the latest development means that, which is that the other side is going to the High Court on a constitutional case, means that the FIU will be able to hold on to the cash for 3 months. But let's break this down and simplify it. Let's remind ourselves what the case was about from the beginning. The case was simply an application not to seize the company's cash, merely to hold on to it for 3 months pending investigation. It was never intended that cases of this sort would be blown out of proportion like this. It's not a determination of guilt or innocence or seizure. At some point down the road, if you feel you have enough evidence, you then apply to keep it, to seize it. This was just to hold on to it for 3 months. What happened today was the magistrate gave a ruling. When we were here last week, Monday, we attempted to lead evidence from an inspector, Inspector Lopez, to show that there were tax evasion offenses. Knowing that once that evidence was led, the case is over for Caribbean International Brewery, their attorneys lodged an appeal. Sorry, not lodged an appeal, took an objection. The magistrate asked for written submissions on this, and she ruled on it today. Her decision was that you can actually lead this evidence. The dispute was over the law. Mr. Barrow took the view that you could only, at this juncture, deal with evidence as it existed when you initially seized the cash in the first 72 hours. We said, no, that's not the correct interpretation of the legislation. The legislation entitles you to hold on to it for 3 months if you can show to the magistrate how the investigation is developing. So if you find new things like tax evasion or money laundering, you can bring that before the magistrate. The magistrate accepted that. Naturally, the other side had to object because once that evidence is in, the FIU's application is made to hold on to the money for 3 months.
To challenge the submission of the evidence, CIB's attorney, Dean Barrow, entered an application to transfer the matter from the Orange Walk Magistrates Court to the Supreme Court of Belize.
Her finding that the FIU, which did not seize the money, remember the money was seized by the Anti-Trafficking in Persons Unit headed by Jian Yong, that it is the FIU that can come to court to ask for continued detention of what the FIU did not seize and to ask for continued detention on the basis not of any justification from the police or the department that did seize the money, but on the basis of justification from FIU officers and Belize Tax Services officers. Again, that is outrageous. As I said, look at it in terms of the analogy of a criminal matter. You charge me with theft, and when I get to court, you leave evidence that I committed rape. That's a violation of my client's constitutional rights, because you must know when you go to court the case that you're being called upon to meet. You go to court on the basis that the case you will have to meet is the case made by Inspector Jian-Yong, who seized the money and who must justify the continued detention. But you are faced then by the FIU, again, totally unconstitutional. That represents a violation of my client's rights to equal protection under the law. The other critical element is this. On the other side's own submissions, when you interrogate the scheme and the wording of the section under which the cash was seized, it is clear that that cash can only be held lawfully for 72 hours. Once 72 hours have passed and no order is made by the magistrate for the cash, for the continued detention of the cash, that cash needs to be given back.
According to Smith, he was able to secure the admission of the evidence through a law that was amended by Barrow himself when he was Prime Minister.
It's a provision in the Constitution that says if you believe that your human rights are being violated, you tell the magistrate you must state a case for the determination of the Supreme Court. So rather than wait for the case to be concluded, he is effectively saying, magistrate, you must put this to the Supreme Court. But in doing so, he acknowledged that by the time the Supreme Court hears the matter, it can't be done. By the time you put in all the arguments and have a hearing and a decision, 3 months will be long, long gone. So in a sense, as you rightly said, the case is over. It's effectively over. FIU wanted to hold on to the cash for 3 more months so they can develop their investigations, develop their case.
And they get to do that.
And they get to do that. The Labor Department, the Anti-Trafficking in Persons Unit, the Immigration Department and Special Branch all did this operation because they didn't like the people. I mean, that's nonsense. They had intelligence of something was going on and they looked into it. They didn't go looking for the cash. In that investigation, they found the cash. And you know why they were able to detain it? Because Mr. Barrow, when he was Prime Minister, amended the law to include Section 38 in 2016, which he is now challenging. It's he who introduced that to give the police more and the authorities more leeway to investigate and develop their case.
Barrow intends to demonstrate at the Supreme Court that his client's constitutional rights were breached.
You can only hold the cash lawfully for 72 hours. So her determining that, no, as long as you make the order in time, I can take as long as is necessary before I give an order for continued detention. That violates the section of the Act, and if the section of the Act means what she says it means, that section of the Act has to be unconstitutional. Every time you search and seize, remember that all of us, all citizens, have a right to protection against search and seizure. But a law can provide for derogation from that right that's proportionate. If you provide that somebody can go and seize cash on suspicion, indeed, you have to provide an end date during which that cash can be held, can continue to be held on the basis only of mere suspicion. And that is why the Act properly says 72 hours. If you can hold the cash beyond 72 hours without a court having heard evidence and determined that we are giving you further permission, then that becomes disproportionate. You're holding the cash without judicial sanction for too long a time, and that is unconstitutional and a violation of my client's rights. So, the bottom line is this. I've asked her, you state a case for the Supreme Court. I know that the other side is saying, no, we will object to your stating a case. Either way you take it, if she agrees to state the case, if she doesn't agree to state the case, there's a way, as I've said, we can go to the Supreme Court to oblige her to state a case. Any way you look at it, we can't get to the Supreme Court before 3 months would have expired, by which time this application before her would have become moot. So we concede that that's no longer a possibility. But we get to the Supreme Court and we can establish that all that she did was in violation, is in violation of my client's rights. Then that will help to found what I've said from the beginning is the action they will in any event take to get redress in the form of damages for the violation of their rights.
On the other side, the FIU's attorney contends the application is not against a person but against property. In this case, it's $3.1 million. We will keep you following the case and bring you the details as they unfold.